Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. In this video, we are going to discuss the provisions of Section 167 CRPC. You all know Section 167 is giving remand by the Honorable Magistrate or taking into judicial custody. You all know if the investigation cannot be completed within 60 days, yes, default bail. If it cannot be completed within 90 days, yes, default bail, 167 clause 2. At the same time, if it is a preventive detention case, 180 days. So the accused must be produced. This is the important point. In the absence of accused, normally no orders can be given. This is the base law. This is what is explained in this particular case. You can read the case as actually Jigon alias Jimmy, Praveen Chandra Aditya, Jigon alias Jimmy Praveen Chandra Aditya versus State of Gujarat in Criminal Appeal number 1656 by 2022, decided on 23rd November 2022, few days back only. Two judges bench, Ajay Rastogi and Abhay S. Okha of the Honorable Supreme Court. The bench observed that failure to produce the accused before the court at the time of consideration of the extension of time. Failure to produce the accused before the court when the consideration is regarding the extension of time. So for purpose of investigation, it is a violation of, or it amounts to violation of Article 21 of the Constitution of India, right to life. Right. Now, if you know the brief facts of the case, then it will be better for you. This accused, that is Jigon alias Jimmy, Praveen Chandra Aditya and three others, they are figuring as accused in Jamnagar City PS case, crime number 1120 by 2020 under sections 3, subclause 1, subclause 2, 3, 4 and 5 of the Gujarat Control of Terrorism and Organized Crime Act 2015 of Jamnagar PS. The case was registered on 15th October 2020. So please remember, this is a very serious case. Control of terrorism and also organized crime. Normally here the minimum period will be 180 days. So normally according to section 167 CRPC, the period of 90 days can be extended up to 180 days because this is a preventive detention case. Alright. So on 21/1/2021, the application filed actually on the 180th day, and on the 10th day special court allowed the petition. But please remember, later the applicant filed petition under section 482 CRPC, that is quashment. So because there is no material, even though the police are allowed 180 days time, they could not file any information before the court, or they could not file the charge sheet under section 173 CRPC. Therefore, he wanted quashment of the detention order given by him. But please remember, the main ground is when the special court passed the order, none of the accused were present either physically or through video conference. This is before getting bail. So the important point is section 167 clause 2 says no magistrate shall authorize the detention of the accused in the custody of the police unless the accused is produced in person. Of course, nowadays in Andhra Pradesh also we have got an amendment at the time of DG Prison Sri M.E. Krishna Rao IPS, that the person can be produced electronically or through video linkage. But if you fail to produce him on the particular date, yes, it is a violation of Article 21. Right. So now, on the side of the government, PP says or argues that failure to produce the accused will not cause any prejudice to him. He was already given a favorable order. Please remember, the accused has got a right to raise objection even from the jail also. Right, ultimately the court already issued granted bail, but the important point is the accused should be produced before the court for the extension of time, maybe in person or maybe through video linkage. So this is what is expected under 167 crpc. Please remember, if the accused is absent, then definitely the extension of time cannot be given because it violates the right to life and liberty as envisaged in Article 21 of the Constitution of India. Very good judgment. Please, you can cite it if the accused is not produced before the court. Jigon alias Jimmy, Praveen, Chandra, Aditya versus State of Gujarat, 2022. With this, I am stopping. Thank you very much.